whether you've already made your legacy plan or if you're thinking that it's time that you actually did something about your legacy plan, odds are that you might be overlooking something. Hi, it's Nancy Beauvair here with a Gappy and NEXsteps. Today I wanted to talk about the top 10 mistakes people make when they're making their legacy plan. Some of these will seem very, very evident, and some of them are little things that maybe you just simply didn't think about. But regardless of that, it's important that you're very aware of the proper construction of a legacy plan. After all, you do want to make your best shot at making sure that you've got all bases covered, and you don't want to leave yourself unprepared or your beneficiaries, your heirs, or your power of attorney left scratching their heads and wondering what was intended. Now, I'm not going to dive deeply into all 10 of these top mistakes here in this video. If you want to read them all and how to avoid them, hop on over to my website and you can read my blog post, which will give you more details about each of the top 10 and how you can avoid them. But let's get started on at least the top 3. So the first thing is not having a plan at all. This is one that well over 50% of Canadians are guilty of, and probably many more than that. I know that there are a lot of intentions there. I have run into so many people who have said, yes, I know I need to do my will. Yes, I know I need to make my plan, but it's not a priority. For whatever reason, they run out of time. Most likely, I think that there is something subconscious in our human nature that wants us to avoid talking about our mortality, dealing with things that make us vulnerable. But we should have a legacy plan in place because the unknown does happen. And if we don't have any plans in place, then who will be your power of attorney? Who will make those medical decisions for you if you're incapacitated and not able to make those decisions for yourself? What about if something happens and you suddenly pass away and you have no will? What happens then as far as what happens to your assets? How is your funeral handled? All of those kinds of things need to be communicated, and they need to be written down so that there's a legal record. Otherwise, what's going to happen is you're going to leave your family members, your loved ones, your friends, whoever is going to be managing your care, you leave them unprepared, and they will actually have to petition the court for the right to make decisions on your behalf. Once they have that right to make those decisions, you're going to be leaving them unaware of what it was that you wanted for your medical decisions, for your transference of your assets or your wealth, for any of those decisions, your medical decisions. You're going to leave them asking questions. Maybe they don't even know where all of your assets are. Maybe you have bank accounts in places that nobody knows about. Maybe you have crypto assets. How are people going to access your digital legacy? So that's the number one reason, is simply not having a plan. Now, one of the other major mistakes that people make is not appropriately planning and naming beneficiaries. Probate is a very time-consuming and can be a very stressful situation for the executor. Here in Canada, it used to be that people used to make plans so that they could avoid probate fees, which vary depending on where your jurisdiction is. Some provinces are reasonably expensive in the scheme of things, while others don't have any probate fees at all. So be sure to check out what the fees are in your jurisdiction. But even more so than the actual fees is the amount of time that it takes to obtain probate. So what probate is it's when the courts in the jurisdiction actually validate the will as being recognized as the last will and testament of the deceased, and they are accepting the legitimacy of the named executor on that will to be able to go forward and manage all of the affairs of the deceased. Now, in some cases, it can take months and even up to a year just simply to receive the grant of probate from the courts. Then once that happens, there is generally, again depending on your jurisdiction, but generally there's what they call the 210-day rule. So once the grant of probate has been issued, you still can't dispense those assets for a minimum of 210 days to allow for creditors to come forward, to allow for challenges to the will by potential beneficiaries and heirs. So you could be looking at easily 2 to 3 years before the assets from a deceased person are able to be distributed. So if you do proper planning, and I would suggest that you engage the services of an appropriate advisor to help you, whether it's a tax attorney or whether it's a trust attorney, whether it's a financial planner, depending on the complexity of your own estate, I would suggest that you employ the services of a trusted professional to make sure that you're structuring your plan in the best, most tax-efficient strategy, and making sure that things are structured so it doesn't leave things open to challenge after you have passed on. Now, one of the nice things about naming beneficiaries as well is anything that has a named beneficiary does pass outside of probate. So it's a good way to make sure that your loved ones aren't left struggling financially while they're waiting for assets to be transferred. The final mistake that I want to address here in this video is not updating the plan. A lot of people, when they finally do go about making their will or making their plans, they don't update things when there's changes. So if you've named, for instance, somebody as an enduring power of attorney, maybe your best friend, and that best friend and you have a falling out, well, you better make sure that you change that power of attorney, because I'm sure that if you're not getting along with that person anymore, that you don't want them making decisions on your behalf, financial and legal decisions on your behalf. So you have to make sure that those are updated. Keep things current. Revisit your will. A will is not a one and done. You have to review that at least once a year, but certainly whenever there's anything major that happens in your life. Now, what's something that is major that happens in your life? A lot of people will slough it off, or they actually don't think that things are a big deal. But what if you've had a divorce? What if you've had another child? What if one of your adult children has had a divorce? Or you've got more grandchildren? If you've allowed for all of these individuals in your will, you're going to have to update your will to ensure that nobody's left out. Again, if you engage the services of a lawyer who specializes in creating wills, maybe some of these updates can be avoided. Maybe you can structure your will such that any future children could also become beneficiaries. But again, you have to make sure that it's worded properly and that your will has been validated properly to avoid having it invalidated when you do pass away and leaving everybody in turmoil again. So that's the top 3 that, in my view, that I'm going to leave you with here. But again, hop on over to my website and check out the blog article for the other 7 top mistakes that people make when planning their legacy. And again, I just want to point out that as a certified executor advisor, I can help you navigate through all of these things. I can help if you already are an executor, or if you have been named as an executor. I can help make sure that your planning is structured properly. And if you are an executor already, I can help walk this walk with you and help make things easier for you. Thanks very much for joining me. I look forward to talking to you next week. Bye for now.